And please make sure all cell phones are on silent.
Court, all rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give me attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. This is a continuation of the January 3rd, 2024 sitting of the Appeals Court. I continue to be delighted today that I am joined by my colleagues, Justice D'Angelo and Justice Hodgins. I am Justice Henry. We at the Appeals Court allow argument of 15 minutes per side. For better or for worse, we do not have rebuttal. And I can assure you that we have read your briefs thoroughly, and usually the record material as well. So your time is yours to use as you would like, but I would encourage you to jump to the heart of the matter. And with that, we'll call the first case, which is 2023 P244, Commonwealth versus Cormier.
May it please the Court, my name is John Calcagni, appearing on behalf of Appellant Mr. Cormier, who asked this Court to set aside his trial verdicts on the grounds that the Justice erred in failing to grant his motions for a required finding of not guilty as to one count of indecent assault and battery on a person over age 18 and 2 counts of larceny over 500. I will address the charges in that order. First, with respect to the indecent A and B charge, the question for this Court is whether or not the intentional tickling by Mr. Cormier of the abdomen of his adoptive and custodial niece was fundamentally offensive to contemporary values and regarded as immodest, immoral, and improper. I concede that the touching of an abdomen can, under certain circumstances, arise to an indecent touching. But when viewing the totality of the circumstances in the context of the touching in this particular case, I suggest to the Court, as a matter of law, that the touching was not, in fact, indecent.
Is it your argument that in this case, and I'm going to focus on this case, that the tickling because of the context of the relationship was not offensive? Is that really the heart of why it's not indecent in this case, because it wasn't an offensive touching?
Well, whether or not it's an offensive touching or not, I don't think is a finding that this Court needs to make in order to determine if it was indecent. The reason I suggest that it doesn't arise to indecency is because you consider the familial relationship, as the Court is indicating here. Second, consider the course of dealing that the trial evidence established between Mr. Cormier and his niece, that there was a course of dealing of this constant horseplay that would go on around the home with regarding to him tickling her. Consider the fact that the tickling was always conducted over the clothing, but for one instance, when the bodies were moving, the evidence was that her shirt came up.
It sounds like this is a fantastic closing argument at trial, which is what a jury has to decide about whether the touching is in fact offensive, indecent equaling offensive. And all of those things were found by a jury to be offensive. So aren't you asking us to put our impromptu on a finding of fact here?
That's one way of looking at it, but the other way of looking at it is that the trial judge should have never let this go to the jury, and that's really our claim of legal error here. If the trial judge had applied the appropriate standards, she would have concluded that no rational jury would have found beyond a reasonable doubt that the nature, circumstances, and facts surrounding this particular touching between these particular parties arose to the level of indecency. And that's really our claim. This should never have made it to the jury.
So you argue that the indecent A and B charge was not based on spanking, but certainly, at least in the Commonwealth's closing argument, they rely in part on that, the spanking of a 16-year-old, as part of the context of this situation.
Your Honor, the spanking came up in the context of the case as sort of an extraneous fact that was raised during the course of the first complaint, when the niece had asked a family friend if the spanking by her uncle was appropriate. That led to further conversation. But the Commonwealth's chief complaint is that the indecent assault and battery was based upon Mr. Cormier allegedly touching his niece's girl part. And then through the course of testimony and very pointed cross-examination, it was established that the touching actually occurred in the abdomen area above the pubic region but below the belly button.
So can you, I struggled in reading your materials, though. Like, can you point us to somewhere in the record that the charge was not based on the spanking? You're just saying it came in as an erroneous fact, so did it not come in during her testimony?
It did come in during her testimony, and there was a sidebar discussion, which is cited in my brief, where the Commonwealth conceded on the record to the trial judge that the Commonwealth was not claiming that the indecent assault and battery was in any way, shape, and form related to the spanking itself, that was an extraneous fact that came out. And by the way, Your Honor, the spanking was something that took place at a different point in time. It was unrelated to the alleged indecent touching, which was the abdomen area. And I raised that in my reply brief because the Commonwealth had argued, as it does in its brief, that the spanking contemporaneous or in combination with the touching of the abdomen arises to indecency, and that was not the issue at trial. I also want to point out that there was some testimony at the trial that the course of dealing involving Mr. Cormier and his niece at the time contained evidence that she would, in fact, instigate or invite the tickling by blocking.
But wait a minute, though. But on page 40 of the transcript, she says, I think you would ask the question, did anyone else, or I'm sorry, it's prosecutor, did anyone else in your life, whether they be family or friends, tickle you? The answer, my mom sometimes will, but she's my mom and doesn't. My uncle, I don't really know him that well. Why he should ticklish me without my permission? My mom is totally different between him, if that makes sense. So it's clearly not something instigated by her. It's not horseplay. It was uninvited. It was unwanted. And she seems to be communicating that pretty well, despite a language barrier.
Your Honor, to respond to that, she's referring to her mom, who at this point in time had deceased. That would have been Mr. Cormier's biological sister, and upon the deceasing of his sister, Mr. Cormier then was ultimately appointed guardian of the two adopted daughters. But at this point, the niece had been residing with Mr. Cormier for approximately a period of 18 months, and the testimony was that the tickling went on rather regularly throughout that period in time, and the complainant conceded during cross-examination that there were points in time where she would block doorways and block the hallways to prevent Mr. Cormier from passing as part and parcel to their ongoing horseplay, and that would be one of the triggering events that would invite the tickling. And yes, as the Commonwealth points out, and to your point, Your Honor, she would say no and stop, but no and stop in response to tickling while laughing and rolling around on the ground is more of an instinctive reaction to being tickled rather than a declaratory statement to please stop that conduct. And that is my argument as to that point.
So, counsel, one thing that strikes me when I read all of this is there seemed to be a language barrier here. Did anybody consider having a translator?
I think that there was discussion about using a translator during the context of the trial, but the Commonwealth felt that based on their preparations, this is all off the record, of course, the Commonwealth had felt that based on their preparations with the complainant, discussions with the new adoptive parent, and working with the victim witness liaison, that the complainant was certainly capable of communicating well in English. And it did, in fact, appear that way at the trial.
Counsel, You just, in response to Justice Hodgins' question, you talked about her no and stop sometimes in a playful manner. However, on page 44 of transcript 2, I think there could be a fair inference the other way. Her answer is on line 16, and I was so scared, I am so afraid of him, I don't know how to. Did that get it? I don't know how to. All right, but, and here's the key sentence, but usually when I say no or stop, it do not work. Isn't a fair inference from that that she tried to get him to stop tickling her on occasion and he wouldn't? And in a required finding, it has to be in a light most favorable to the Commonwealth. So isn't the inference that she said stop? There was no consent to the touching.
There were a number of behavioral issues that were going on in the home that Mr. Cormier and his spouse were trying to address with this particular niece. Issues surrounding the attendance of church, attendance of classes, the performance of chores around the home, and this particular niece was rather rebellious. And as a result of her rebellious behavior, there were a number of conversations regarding things that were happening in the home that made her feel uncomfortable. Her then adoptive parents, her aunt and uncle, not respecting her desires, her freedoms, her wishes to pursue her culture, things of that nature. At no point in time did Miss Cormier, the niece, during those conversations, raised the tickling and the contact that was transpiring between her and her uncle to be harmful, offensive, or unwanted. My understanding and recollection from the testimony at the trial is that she would say no or stop in the context of the tickling instances. But it's important for the court to be reminded that these folks lived under the same roof for a period of 18 months. This went on in numerous times, sometimes at Mr. Cormier's initiation, and other times at the niece insinuating or instigating by blocking the hallways and teasing him and being playful with him. And when you look at the totality of the circumstances, the relationship, the context, what was going on in the home, the Commonwealth recites the age disparity, but there was a diminution in the young lady's level of maturity. I suggest to the court that even if we were to determine that this was improper, it just doesn't arise to the level of indecency. And what I found to be particularly instructive as I really dove into this issue for this particular appeal was Justice Milkey's concurring opinion in the Cruz decision, and how he goes on to talk about the broad pronouncements of this court and other decisions as it pertains to indecent assault and battery, and for the court to be able to set forth standards that can really be instructive to a jury and put defendants on notice as to the type of conduct that's going to be acceptable and when it's not going to be acceptable to the law. And when you consider that the contact here was not in a straightforward, intimate place like the vagina, the breasts, etc. There were no sexual connotations, innuendos, attempt to remove clothing, statements, or anything indicating some sort of a prurient interest or a sexual intent. I just suggest to the court that the facts of this particular case, the tickling of the abdomen, don't arise to indecency. I note that I'm coming close to my timeline. I've got about 3 minutes left, so I just want to pivot very quickly to the larceny charges. I think the arguments I set forth in my brief are relatively straightforward. These funds, which were coming from Social Security for the benefit of the girls, which we concede, were deposited into a joint bank account. The law on larceny requires the taking of a property of another. From a legal perspective, once the funds are deposited into a joint account, they become joint property.
Yeah, but counsel, I mean, we have cases where, like, if you have a car that's titled with two people and then one of the people goes out and, like, slashes the tire, you can be convicted for malicious destruction of property, even though that person's name is on the title, because the other person, that was, like, their car. So that seems like, by analogy, you know, his name might have been on the title of that account, but it was their money.
Well, in that particular case, Your Honor, I can't speak to the facts of that particular case, but when you look at the elements for larceny, it requires the taking of a property of another, and there might be other remedies.
Could he have taken this? Let's just make it a pure hypothetical. Could he have taken this money for a vacation for himself?
He could have. He could have. And there would be other remedies under the law available. But the point is, he was the appointed guardian. Social Security was giving him that money to use in his discretion for the benefit of the family and the children with whom he was caring for at the time.
So that's the part right there I was going to ask you about. The money is given to him for the benefit of.
That's correct.
The Commonwealth presented evidence that some of that money was not being used for the benefit of the child, but for the benefit of himself.
Without a doubt. However, it was deposited into a joint account.
By him.
That's correct. No, by Social Security. By Social Security. It was directly deposited by Social Security. And he was appointed by Social Security to be the guardian of the children. And I'd suggest to the court that there are certainly other remedies available, whether they be under federal law or through civil causes
Yeah,
of
but
action.
aren't you conflating bank terminology with legal terminology? I mean, if a bank says it's a joint account, that doesn't necessarily mean it's joint property. That's just how the bank administers its accounts. Because we have here someone who's under 18, so she's not going to have the capacity to enter into a contract with her uncle to create this joint property. So how is it that we can call it joint property at all? It's custodial. It's a custodial account, in fact.
There are custodial accounts, Your Honor, trust accounts, things of that nature. But this particular account in nature was a joint account. And legally, I'm arguing to the court that once the funds were deposited into this joint account, they became joint property. Now, if Mr.
But who
Cormier...
decided that it was going to be a joint account? I mean, we see people who are the rep payee for Social Security all the time. Are you saying it could go into like a uniform gift act to minors or some sort of trust account?
I would suggest to the court that had it gone into one of those other forms of accounts, we wouldn't be forced with the issue of joint property and the property of another legal argument that was made below.
Okay.
Who formed the account?
Mr. Cormier formed the account.
So wasn't that improper? It should have been an FBO account for the benefit of. So he chose to put it in that, make it that type account, so then he could take the money out of it?
Well, whether or not it's improper or not, I can't answer that particular question. I'm just suggesting that once the funds were deposited into a joint account, they became joint property, and therefore he didn't steal the property of another. Thank you.
May it please the court. ADHE Chile from Middlesex on behalf of the Commonwealth. I'd like to recognize George Washington Law student Allison Chesky for her work in the Commonwealth's brief in this case. I disagree with my brother, firstly, that we need to look at the context of the indecency when the defendant tickle and spank the victim's buttock. Because in Mosby, this court has held intentional unjustified touching of private parts such as breasts, abdomen, buttocks, thighs, and pubic areas of a female constitutes indecent assault and battery. This court later in Rosa in 2004 and Cologne in 2018, that's 93 Mass Appeals Court 560 2018 case, has distinguished between sexual parts and private parts. So intimate parts or private part, that's only when this court will look into the context. In this case, both the buttocks and abdomen are sexual parts of the victim, and that itself is indecent. There's no other way for this court to look into the context in this point. And in terms of whether the victim's mom touching or tickling the victim is indecent in that context, my response would be that is justified because there's a parent-child relationship. That's very different from the victim in this case where she barely knew the defendant as she testified
Yeah, I don't
to.
understand this barely knew situation. Hadn't she been with him for 18 months?
So the tickling began when she turned 16, so that's about maybe 6 months in when she moved into the apartment or the house. So the most important thing is, it is for the jury to decide what happened in the light most of the Commonwealth. The victim testified that she barely knew him. They only met him on major occasions before she moved into the defendant's house. So I think if you look
At the time that you are alleging the indecent assault and battery occurred, how long had she been living with the defendant and his spouse?
So she lived there for 18 months, and she was adopted when she was 13. So by the time, and she spent 2 birthdays there, which is when she turned 16 and 17. So I would say she probably moved into the house few months before she turned 16, and then moving, and from there 18 months. So I understand this court's concern when she spends 18 months there, but the victim did testify that it was different relationship compared to hers and her mom's.
Doesn't it come down to, and your opposing counsel didn't mention it much, but doesn't it come down to consent? The reason why in some circumstances the touching of, and I'm going to use the context of this case, an abdomen, is there would be consent. This case, because it's not a child technically, there has to be consent or not consent.
Certainly, and that's one of my friend's argument is there was no consent, but the victim testified, as Your Honor observed earlier, that while she would say no or stop or push the defendant away when she was tickled.
Well, let me ask you about that. In your brief on page 16, 17, you say that the girl said no or stop. However, the prosecutor in closing argument spent a lot of time in the fact that she never said no. So which is it? Commonwealth can't have it both ways. It's either she never said no or she did say no. Which is it?
Yes, Your Honor. Evidence showed that she did say no. The Commonwealth's closing could have been more artfully presented, but it was, I would say the evidence showed that she did say no. So, and closing argument is not evidence. The jury heard the evidence and was instructed on all the elements, including the buttocks and abdomen in this case. The jury was entitled to find, to give a verdict in this case. The evidence was sufficient in terms of indecency and the consent issue.
So what about the defendant's argument that she invited the tickling by standing in the defendant's office doorway or otherwise blocking him in like a hallway?
Like Your Honors observed earlier during my friend's argument, that really just the argument goes to the jury. It's not looking at evidence in the light most favorable to the Commonwealth. If there's a consistent statement or story, then the ones that resolve in the Commonwealth's favor will trump. And in this case, the victim testified clearly she said no or stop when she was tickled or when she was spanked.
So is your argument that the no comes from that one line that I read in the transcript where there's an inference, which would have been transcript number 22 at line 40, on page 44?
That is one area. You can also look at transcript volume 1, page 183. That's also when she said no or stop. So she did testify at these areas that she would sometimes say no or stop to these touching. So that itself shows that the victim did not give consent, and the defendant should understand that no is no, and he should have stopped. But he consisted this touching for years. And I'll briefly respond.
So I guess I hear what you're saying about that, but tickling is a complicated subject, and many would argue that it is abusive. But you are basically potentially asking us to criminalize tickling, because a lot of people, almost everybody who gets tickled says no.
I think in this case, it's not just tickling. He was tickling toward the private part, and that private part is between the belly button and the girl's pubic area. That is a very sensitive area that this court has said that is a sexual part of a female. No one should be touching others, even parents with touching a 16, 17-year-old girl in that way. That is inappropriate, especially in this case when the defendant was only a guardian to the girl.
So the defendant says that the Commonwealth conceded on the record that this wasn't about the spanking. What do you say to that?
Yes, Your Honor. I agree that during sidebar, the Commonwealth did say that the theory of the case was not spanking or was about the touching of the touching of the girl parts. But the Commonwealth's theory or the Commonwealth's opening or closing is not evidence. It's not, and the Commonwealth is not bound by that when reviewing the sufficiency of the argument because there was no bill of particulars. The Commonwealth is not bound by any proof in this case.
Well, I know, but I mean, in terms of just due process and fairness to the defendant, if the prosecutor says it's not about X and now you want to argue on appeal, it does include X, how is that fair? I mean, he's trying to meet your argument.
I think that would be certainly an issue if the defendant had never crossed the witnesses on this, but the defendant did so in this case. On page 147 to 140 on volume 1, the defense counsel cross-examined the first complaint on tickling and spanking these areas, and for the victim on volume 2, page 39 to 45, and page 48, there was cross-examination on both tickling and spanking. So the defense counsel was on notice, and he knew these were parts of the allegations. They come in opening and in closing. I understand there are some confusions as to exactly what the Commonwealth theory was, but the jury heard the evidence. The jury was instructed correctly based on the evidence. Under Jones, which is this court's opinion in 16 Mass Appeals Court 931 and 1983 case, the judge is not bound by the Commonwealth theory that advanced at trial. The judge is bound by the evidence presented at trial. And the judge correctly instructed.
Can you point in the transcript, if we have it, because I know we sometimes
Yes,
do
Your
and
Honor.
don't, where the instructions are regarding what the actual act is that the defendant was on trial?
Certainly. So it's on Volume 2, page 179. That is instruction on indecency or indecent touching. The judge's instruction closely tracked Mosby, which is from the model jury instruction, which the trial judge talked about breasts, abdomen, buttocks, thighs, and pubic areas of a female that would constitute indecent assault and battery.
Right, that's just the general instruction, that no one, the judge never isolated it to a particular theory, just left it for the jury.
And there was no specific unanimity instructions. The jury was free to give a general verdict, which they did in this case, and found the defendant guilty of indecent assault and battery.
Isn't it the law of the case if the prosecutor tells the judge we're not going forward on the buttocks?
It is a law of the case if the court had made a ruling, but there was no such ruling. The Commonwealth did make a clarification to the panel. I understand why this court is concerned about that practice. And I can see that the trial prosecutor should have tried the case more artfully, but the Commonwealth is not bound by that advancement at trial because there was never communicated to the jury. There was no bill of particulars. The trial judge properly instructed based on the evidence.
But you're not suggesting that it was a common act, that the buttocks and the tickling were in the same time frame. They're two separate acts here.
Correct.
So how do we know what the jury, first of all, how do we know what the grand jury indicted the defendant for? And number two, how do we know what the petite jury found the defendant guilty of then?
So the complaint only said indecent assault and battery. There was no specific allegation of the fact, and there was no request of bill of particulars. If the defendant had requested one, the Commonwealth would be bound by that proof, but there was no such thing in this case.
I saw references to a verdict slip, but I didn't see it in the record. Is there?
And I believe that it's also just a general verdict, and especially there was no specific unanimity instruction. So the jury was free to use any evidence presented to them to find the defendant guilty of indecent assault and battery. And this court really does not need to resolve the spanking issue.
Do you have any case law that suggests that a jury can find the defendant guilty of separate acts like this? I know there's case law that talks about if it's in the continuing course and there were two touchings, or it comes in the context of fights a lot, where there's a punch and a kick, etc. But these are two separate and distinct acts of indecent touching from your argument. What happens if we reverse? Is there double jeopardy as to one act and not the other?
I think if you reverse, the Commonwealth would be bound by that reversal because the evidence was presented to the jury, and that would be it in this case for indecent assault and battery. And no, I don't have a specific case. But this court in Jones, in that specific case where the Commonwealth advanced on the theory of joint venture, but not advanced theory on felony murder, this court held that it was okay, it was proper for the judge to instruct the jury and for the jury to find a verdict based on that theory that's not advanced by the Commonwealth. So this court had made something similar before. Just because the Commonwealth advanced a specific theory does not mean the Commonwealth is bound by that theory on an appeal. I understand this court's concern, and obviously moving forward, the Commonwealth should be more consistent in terms of theory, but that's where the bill of particulars come into play, where the Commonwealth can be bound by its words and to have a clear path at trial. And I'd like to briefly touch on the larceny issue about access.
But just before we get to that, a couple
Yes, Your
of
Honor.
questions. The defendant argues that the Commonwealth wants it both ways, emphasizing on the one hand the victim was 17, and so all this, we'll call it horseplay, but that's, as a shorthand. But then the Commonwealth then turns around and emphasizes that she had the maturity of a 9-year-old and had some developmental challenges. So, what do you say to that?
I think it really just comes down to what evidence was presented to the jury. That argument, again, is not in the light most fair to the Commonwealth. My point about there's age difference, whether it's 9 or 17, is the defendant was 45, and the victim was 17. She has developmental issues. There was difference in experience and sophistication, and the victim was held down when she was tickled most of the time. This really shows, if this court even were to look at the context of touching, it would show that this is very inappropriate and indecent. Indecent does not mean sexual. Indecent, it just means that it's immorally inappropriate, morally inappropriate, and that's what happened in this case. There was an age gap. There was different experience gap, and the victim was slow in some way. So that really just shows that even if you look at the context of tickling, that would be enough for indecency.
So what I want to be clear about, though, let's just, to make this, take this away from this case, hypothetically, if you had a father, and he was a father from the moment of conception, and he had a 17-year-old, and he tickled her and held her down, and because this is how tickling goes, and held her down, and her shirt rode up, and he touched the area between her belly button and her, like the, waistband of her pants, but never went under the waistband of her pants. Are you saying that act would be criminal?
At that point, I think it's appropriate for this court to look at the context. And if you look at Cruz, in that case, the court found the practice of the family, right? So if there's a practice that is a common thing that I have had since the victim in question is a child, that would be a very different situation. That is not what happened here. There's no prior practice or routine that this is happening to the victim between the victim and the defendant. This is the case where the victim came to the defendant's home and the tickling began. So if you look at the context, the Cruz, that would be a very specific situation. Or this court's case in Vacas in 2004.
Wait a second. Once the victim came into the household, there was repeated tickling between the defendant and the victim. So there was a course of conduct. It's not that every tickling between the defendant and the victim in this case was indecent. You concede that.
Correct. But the difference is it did not begin when the victim was a child. It began when the victim was already 16 years old. And that's the main difference here. If you tickle a child when the child is 1 year or 2 years old, that might be a normal parent-child.
I think this goes back to Justice Henry's earlier question, though. You want it both ways. For the purposes of one part, she had the mindset of a 9-year-old, which I think we could agree maybe tickling is appropriate. But at the same time, you're also arguing she's over 16 and it's not appropriate. So which is it?
I think the testimony also says she's jumping back and forth on the maturity. It's not just she's 17 and presented as 9. The first complaint witness testified she sometimes presents as 9 years old, sometimes presents as 16 or 17. And that's really the reason why the Commonwealth argued both, because the victim presented under both age. And that's why the Commonwealth could use this evidence to show the context of this case. The touching was indecent. I'll just briefly touch on...
Just to be clear, though, I worry whenever the Commonwealth or the Department of Children and Families makes an argument where if we accepted the argument, it would require us to, say, in the Department of Children and Families, would require us to remove pretty much every child from the home of their parents. Like, for example, when the department argues to us that there was a cat on the counter, and so therefore that house was unsanitary, and I'm like, that is not... So here, what you wrote in this brief was that the defendant forced the teen to attend church. And you attach a sinister meaning to that, and many, many, many parents force their children to attend church. So what is the relevance here that he forced her to attend church?
So at a time that was presented in trial was really just showed the relationship between the defendant and the victim. They were not close. They were not seeing eye to eye. And I believe the defendant wanted that evidence at trial because that it shows that, like my friend argued earlier, she, in their eyes, is a rebellious child.
You are arguing it to us in your brief, I believe, that that this was somehow bad, that he forced her to attend church. And I would worry for the parents of the Commonwealth if we took that into account.
So I want to clarify, the Commonwealth did recite that fact in the facts section, but the Commonwealth did not use that as an argument in the argument section. So I'm not suggesting at all that a parent suggesting or quote-unquote forcing a child to attend church is inappropriate. That's not part of the case here.
Okay.
The case here is about the indecent touching.
I know you've been trying to get to the second argument. Let me just, do you have any questions? Okay, we'll give you a minute on the second argument.
I will just summarize what the panel's questions to my friend, which is, under Bachman, just because there's a facial appearance of joint venture, joint joint account does not mean that it's actually joint ownership. In this case, the testimony showed that the victim, these money came to the victim for the victim's purpose
I
only.
think we understand it, and we
Yes.
can leave
so
that here.
if there are no further questions, count rest on its brief.
Thank you very much. Should we do it now? Should we do it? I'm okay with that. We'll just, okay, thank you. Just so you. The next case is 2023 P168 Commonwealth versus Gomez, and this case is partially impounded. I want to remind council, and I'll just also let everyone know there's some sort of glitch, and we're streaming and recording the audio only, not video at the moment. We will take a break, not after this case, but after the case after that, and we'll get that fixed, but I don't want to delay the parties that are here before us. So if counsel for the defendant, Counsel Hurst-Quisk.
Thank you very much, Your Honors. I appreciate your time. For the record, my name is Richard Harquist, and I have the privilege of representing Jose Gomez in this matter. My brief is essentially divided into two portions, and I'd like to argue the first one in that order, but probably put less emphasis on it and be a little more brief in that context. I argue that that penetration is not even alleged by the testimony collected at trial. Even taking the facts in the light most favorable to the Commonwealth, if we look at page 25 of the Commonwealth's brief, we see the summation of what's alleged, and penetration is not. And the case law is very clear that there has to be penetration, otherwise we have no separation between lesser offenses and the rape charge itself. In other words, you can't have a gray area where it may be a rape or it may not be a rape.
So you're saying where the, I guess I'll just say child, testified that he opened her vagina with his two hands, that's not sufficient to prove penetration?
I'd argue it's certainly not. It's not penetration. Penetration is an intrusion. Under the Ragus case, penetration is an intrusion into a genital opening. So no, I would argue respectfully that that's not the case at all. And that does put your finger on the point, because that's probably the most severe portion of the accusation, right? And if we argue that, and if we can argue that that's not penetration, then certainly we may have a sexual assault, but we don't have a rape. Okay, and I'd like to move on to the ineffective argument at this point, Your Honors, if it pleases the court. And I'd respectfully recall that this is a close matter, factually, because we had a mistrial, we had a hung jury the first time around. So part of what I'm before the court arguing for today is that we should have had an evidentiary hearing on this matter so that we could explore the facts of the ineffective assistance of counsel claim.
Counsel, I'm sorry. I am going to go back because I had to look it up to your previous argument.
Sure.
Under Commonwealth versus Donlin, and I believe it's at 336, the element of penetration required for a rape conviction is established by evidence that Donlin touched or came into contact with the victim's vagina, vulva, or labia. Quote, intrusion into the vagina itself is not required to make out the wrongful penetration. Touching is enough.
So, I hate to use the terms, Your Honor, but what that case, or how I interpret that case and how it has to be interpreted based on our law, is that, yes, a touching of the interior, right, the clit and the vagina, I'm sorry, and the clitoris and the...
It's okay, we're all adults here. I think, are you arguing basically if somehow he had opened her legs and he had somehow touched the intersection between the leg and the groin and used pressure to open the vagina, that would not be enough, because he didn't touch
right,
the
and
labia,
that seems,
you know, if that's...
It seems to be what was alleged, right? And then she puts her pants back on and walks away. So yes, essentially that's my argument in a nutshell. And I would cite, for Your Honorable D'Angelo, Nylander, Bratman, and King. King is 445 Mass 217, and also the Ragus case, R-A-A-G-A-S, as cases that clearly state that there has to be penetration. Now, we can revisit the point, too, is when there are juveniles, young children who are on the stand and testifying about what occurred, the case law is pretty clear, right, that the inference can be made that there was penetration based on words that aren't so exact or mature, right? But we have a 21, 22-year-old woman on the stand here. We can't make the inference. We have to hear some evidence of penetration, and I respectfully argue that we didn't. Moving on to the ineffective assistance claim, as I said, the defendant is really seeking a hearing on the issue of ineffective assistance for the failure to oppose joinder, for the failure to even object to the admission of prior bad acts, and for the failure to complete a thorough cross-examination or impeach the people involved. Now, beginning with the joinder, the case is joined, and we now have witnesses that wouldn't be able to independently testify at the trial of one another, right? We have first complaint witnesses. Now, in essence, victim one offered two first complaint witnesses because her mother gave a whole rendition of the genesis of how she learned of the offense. And then we also have the actual the named first complaint witness, Ms. Rodriguez. And Ms. Rodriguez testifies about the first time that there was a disclosure and the mother wasn't present. That was in the bedroom. All right, so we join the cases. We have two first complaint witnesses for victim one. Now we've joined in victim two, who's presenting a whole nother incident. And the reason I'm bouncing a little between the first and the second portion of this argument is because now we have prior bad acts coming in at the same time. We join in, we add Ms. Moran as the first complaint witness for victim number two. This all occurs behind the backdrop of victim number two not even making an allegation until 13 months after this case was in the chute. So a very strong argument could be made that I'm defense counsel. I just spent 13 months preparing this thing for trial. Now you're joining another case. You're adding a new first complaint witness. Of course, there's no objection. Now, my argument here is the Commonwealth's going to want to call it a strategic decision and say that we have to prove manifest injustice, right? But it's also a decision that rises to the level of a constitutional violation because effective assistance of counsel is a constitutional right, okay? So
I guess I will follow up on what the Commonwealth will argue. The affidavit that was filed, I believe it was you, contacted trial counsel, but there is no affidavit saying it wasn't strategic because he didn't get back to you and your client wanted the brief filed, et cetera. How do we not know? How did the motion judge not know it wasn't a strategic decision without an affidavit?
There's a few ways that I would argue that respectfully. First, it seems incongruous that it could be a strategic decision to add witnesses against your client. I would argue that the face of the transcript illustrates that mistakes were made and that effective assistance of counsel was not afforded to Mr. Gomez. Second, putting the onus on the defendant to get an attorney being accused of ineffective assistance is a very difficult step. I personally contacted and spoke to trial counsel more than half a dozen times, sent multiple drafts of an affidavit requesting that he review and sign or edit and sign. I didn't get an edited version. Now, when that occurs, it seems incumbent upon the trial judge to give us an hour. Call him in, put him on the stand, let him say it was a strategic decision.
It's not a matter of time, counsel, but your affidavit also doesn't say that when you spoke to counsel, he said it wasn't a trial decision, which you could have put in the affidavit if that had happened.
It didn't happen, and that's why I didn't put it in the affidavit. But again, referring to the face, all right, the transcript itself, when a defense counsel sees another case being joined, he files a piece of paper objecting and explaining that this is different, time and space is different, the alleged victims are different. Granted, they're the same age and they're in the same household, but each individual event is drastically different, right? Once is in a car, once is in a closet, once is in the kitchen floor. And there's allegations surrounding all this made against the defendant seem to change between trial number one and trial number two, right? My mother was in Florida when the closet event occurred. My mother gets on the stand and testified she never went to Florida or the Dominican Republic or Puerto Rico during these times. So we have stories that become inconsistent, and they're being bolstered by the addition of a new defendant and a new first complaint witness. And that's unfair to the defendant. And what we're trying to do here is just make sure that the trial's fair, They can try those two matters separately, and he can confront.
Yeah, but
them
isn't it
separately.
possible that the defense counsel and the defendant made a judgment that you didn't want to go through another ordeal of another trial, and that there was a level of confidence going into the trial that, you know, you have a good shot at being acquitted here, and let's end this in one trial?
Well, I'm saying that even the first trial shouldn't have been a joinder. There shouldn't have been joinder in the first trial, right? So I would argue to this court that certainly the additional witnesses are tipping the scale, and they're giving the jury a whole lot of additional information from complaining witness number 2 that what actually is alleged did occur to complaining witness number 1, because complaining witness number 2 was also involved. And again, I want to circle back, right? Why not just have a hearing and bring trial counsel in and ask them? Because that's essentially what we're trying to do. We're trying to get inside trial counsel's head a little bit. And he could get up on the stand and say, hey, look, I had 7 conferences with my client. My client didn't want to do 2 trials. He wanted to do 1 trial. I advised him against it, but he insisted.
And again, if your client had written an affidavit himself saying something like that, that might be persuasive. But your client didn't write an affidavit for the motion for new trial saying, I never had a conversation with my lawyer, etc. We see those all the time here. So
Can't we still get, I'm sorry, I don't mean to
the
interrupt
fact
you.
that we don't have that is meaningful.
It still puts us back to the place where in the terms of judicial economy and in terms of justice, it's easier to find out from trial counsel why he conceded joinder, why he conceded to allow prior bad acts to come into evidence. Okay? So again, we're piling on information that's against the defendant. I also talk a little bit about, I wanted to point out that it appears to me that through the lack of objection, trial counsel increases the standard and the burden for appellate counsel. Right? Trial counsel is also obligated to make a clear record and to make objections where they're suitable so that we don't have to have a manifest injustice standard to confront on the appellate level. Those objections weren't there. He agreed to joinder, and he conceded the prior bad acts can come into evidence. He didn't put even lodge an objection for the record.
But again, isn't there, you know, I mean, to give counsel some credit, perhaps he made a judgment that, well, this is probably going to come in anyway. It would be unavailing to oppose this, and he's focused on something else in the trial, or maybe operating on some, you know, belief, as I said before, that, you know, he's got a good triable case here.
Because he wants to hang his hat on certain facts in the case certainly doesn't mean that he wouldn't lodge an objection for objectionable or inadmissible evidence at the same time.
Well, so you're suggesting that counsel has to be effective, you have to raise an objection at every possible opportunity.
I think counsel's obligation is to raise objection every time something is objectionable to be effective. But part of my argument is, and you go right to the heart of it really, is there were numerous mistakes made. During the course of a trial, defense attorneys make mistakes. We all know that. No one's going to be flawless during the course of a trial. What I'm arguing here is that the mistakes were piled up, and that bringing in basically additional witnesses against his defendant. And what if he said to Mr. Gomez, I think that this is a triable case because of all the inconsistencies between, even the first complaint witnesses made some inconsistent statements, right? Well, I think it's a good case. I think we shouldn't oppose joinder. That turned out to be inaccurate. And the idea of opposing joinder is one of the most basic that we see in all cases where there are co-defendants. Joinder is always a point of contention and argument.
Right, but I think the issue and the reason the standard is the way the standard is that counsel can make informed decisions, and we can't second guess that.
But
Just because it didn't turn out the way they hoped, it doesn't mean it was a wrong decision.
But it can be manifestly unreasonable at the time the decision is made, correct? Our case law does say that. So I would argue to this court that it was manifestly unreasonable to allow these cases to be joined without objection. And it was manifestly unreasonable not to object to a prior bad act to come in. And those two were intimate.
Let's just pause on that, though, for a minute, because why is it not possible that defense counsel thought the second person coming forward over a year later makes, first of all, it undermines that charge, because you can have this argument about, wow, they didn't even disclose, even though they knew at that point their sister disclosed. And then they can then turn around and take the second witness and say, like, well, that person came forward because they knew there was not there, to bolster the inadequate complaint of the first sister. Why is that not something that counsel could have thought?
I'd respectfully argue that it's not just the second sister who's coming into this picture now, right? And granted, she's bolstering the claims of the first sister, but we also have the first complaint witness coming in, bolstering the claims of the second sister. So what we've done is we've piled on. In all the cases, there's a lot of case law that says, well, even though these indecent assaults occurred in the same doctor's office by the same doctor using the same crass language, we're not going to put 9 victims into one case because the jury will be overwhelmed.
What do we do with the fact that the motion judge made a finding, basically, that said, even if he had objected to joinder, I would have allowed it because they fall into the cases of multiple victims, single defendant, some of the evidence would be admitted against one another, et cetera. What do we do with that finding? Do we just ignore it?
It's a retrospective finding, number one, right? Number two, I would argue that counsel didn't argue. The judge doesn't know what she would have heard on the basis of this. And I know I'm over my time, so I would respectfully argue that he should have at least lodged an objection to it so that we could go forward at a different standard at the appellate level.
Let me just ask you one quick question. Did you raise the issue of the argument? Or
Did I raise
Did you raise the issue of the lack of an evidentiary hearing in your brief?
Well, the basis of my brief was a request for an evidentiary hearing, and I put in the procedurals that I asked for one, and it was denied.
Did you raise it as an argument that you should have had an evidentiary hearing?
I believe, and I hate to say I'm not positive, and I will certainly double check for Your Honor, but I believe I did say that a evidentiary hearing should have been allowed. Thank you.
Thank you very much. We'll hear from the Commonwealth. Councilor Burns.
Good morning, Your Honors. May it please the Court. Kayla Burns for the Commonwealth. The Commonwealth asked this Court to affirm the motion judge's denial of the defendant's motion for a new trial and to affirm the defendant's convictions in this case. And just for the record, the names that I'm referring to in this case for the victims are pseudonyms. I'll first address the defendant's argument as to the sufficiency, as to the rape of a child charge, as to the abuse of Taylor, which was the second indictment that was issued in this case. And I think Your Honor pointed out the case law that is directly on point in this case, that it's well settled in the law that intrusion into the vagina itself is not required to prove wrongful penetration. And here the victim testified.
What is the act of penetration here?
When the defendant touched the victim's, she uses the word vagina, but I think it's a reasonable inference that the jury could have made that the defendant touched the victim's labia or vulva in this case.
Do you have the record citation for that?
Yes, I do, Your Honor. It's obviously the second trial. It's volume 3, page 65. And that's where the victim testifies that the defendant pulled down her pants, opened her vagina with his 2 hands, and I believe later on cross-examination, the victim also states that the defendant put his hands on her vagina and opened it with his 2 fingers. Again, I think the victim used the word vagina in this case, but I think it also supports a reasonable inference that the defendant used his hands to touch the victim's vulva or labia in this case, which does meet the legal standard in this under several cases, including cases cited in my brief, Omand, which is 84 Mass Appeals Court 231, which says that there was sufficient evidence as to digital penetration where the victim testified that defendant touched her clitoris. And again, the case law cited by Your Honor, the touching of the male by the vulva or the labia is intrusion enough, and that is enough to legally satisfy the Commonwealth's burden in this case. So I think those cases are directly on point in this case and address that issue. So I'll move to the issue of ineffective assistance of counsel, and I believe it's my understanding that counsel did not argue on appeal that he was entitled to an evidentiary hearing on this motion. And I think the case law is also very clear on this issue that the motion judge, who was also the trial judge, had the ability and the and the authority to deny this motion on the papers alone. And I think it is very important that there was no affidavit from trial counsel. And this is not a case where appellate counsel sought to contact defense counsel and he never heard back at all. I think this is a case where it's very clear that appellate counsel several times spoke to trial counsel, provided counsel with several affidavits to sign and provide in support of this case, and counsel did not do so. And the motion judge was entitled at that point to draw negative inference from this lack of an affidavit from trial counsel and assume that that's because a truthful one would not be helpful in this case. So I think that is instructive on the issue. And I think even putting aside the judge's finding as to particularly the joinder issue, I think when we look at all of the issues raised under the ineffective assistance of counsel blanket, that all of those issues, even separately from the fact that there was no affidavit, there is no support for those arguments as well.
Just as a structural matter, why should we allow a defense counsel to just say, no, I'm not providing an affidavit? Why shouldn't we have them just come in and testify to what they're going to testify to?
I mean, certainly having counsel come in, I think, and testify would provide a benefit to a defendant, but that my understanding, and I think the case law supports this, is that judges do have the discretion to take into account why there is not, or if there is not an affidavit from counsel, and they are entitled to make an inference from that lack of an affidavit.
I know, but I mean, I will say, we see this in cases, and it may be that it's exactly right, that the testimony, he wouldn't sign the affidavit because the testimony wouldn't be helpful. But we also still draw that inference when counsel's been disbarred for drug use. And I'm like, well, their testimony might well have been different, but we structurally allow that. I realize it's not this case. But I'm like, why is that okay?
I'm not entirely sure, Your Honor. I think, especially in the facts of this case, that the judge's finding and the denial of the motion without a hearing was appropriate. I'm not sure structurally what is the appropriate practice, but I think when we look at the facts of this case here, I don't think those concerns are raised. I think it's very clear that it was appropriate that the judge denied this motion without a hearing in this case based on all the facts that I've already outlined to the court. So getting into the specific instances that the defendant's claims were ineffective assistance of counsel. I think first as to the joinder issue, I think the defendant had to prove not only, and he's arguing that he should have at least objected to the joinder, but I think especially on appeal here, the defendant has to show that such an objection would have had a likelihood of doing something material for the defense. And I think, again, even putting aside the judge's finding in her decision that she would not have allowed a motion to not join.
Retrospective ruling.
Right. I think even putting that aside, I think when we look at the facts of this case, it's very clear that it was appropriate that this case was joined. And I think that the motion judge also noted that this case does fall comfortably within several cases that describe multiple victims for one defendant and when those cases were joined. And I think the facts here that are particularly important.
Do you see any advantage to the defendant in having the cases joined?
Certainly, Your Honor, and I think the main thrust of the defendant's argument in this case was that the two victims were essentially fabricating these claims in order to divert attention away from tension in the family based on Tina's sexuality. And I think the fact that the defendant had both of the victims testify, and I think Your Honor rightly pointed out as well, that this second claim by Taylor came a year after the first claim was made by her sister. I think the fact that both of these victims testified, that their mother also testified, and that all this evidence came in at one trial, I think it certainly bolstered the defendant's case, and I think that's plainly clear when we look at the cross-examination done by trial counsel. He extensively cross-examined each of the Commonwealth's victims and each of the Commonwealth's witnesses in this case. And I think in my brief I point that out. He points out inconsistencies both between their testimony from the first trial and the second trial, and inconsistencies within their testimony in the second trial as well. So I think even when we look at the fact that he did not object to joinder in this case, I think, again, the facts of this case make plainly clear that it was appropriate that these cases were joined. And I'll just briefly touch upon the other instances of ineffective counsel raised in this case. First, as to the uncharged instances of sexual assault. Again, the defendant did not object to these coming in, and there is a discussion in a motion in limine hearing that these instances did come in the first trial, so counsel recognized that they were likely going to come in again in this trial. And in addition to that, the defendant did also use this testimony to bolster his case as well, where he used an inconsistency between the victim's original recitation of what happened and what her testimony at trial was. And in addition, the judge did give a proper limiting instruction when these came in, and the Commonwealth did elicit this testimony for the purpose of showing the full relationship between the defendant and the victim. So again, for all of those reasons, counsel was certainly not ineffective for failing to object to these instances coming in. And again, I think it actually helped bolster his case where he was able to point out more inconsistencies. And I'll just briefly...
Well, what about the argument that counsel had the transcript from the first trial and failed to show the jury inconsistencies between the testimony in the first trial and the second trial?
I can't remember specifically, and I know in my brief I list out several of the inconsistencies that counsel points out. I can't remember specifically which ones were from inconsistencies between the first and second trial, inconsistencies between prior statements to officers and testimony at trial, but I believe that the defense counsel brought up inconsistencies in all of those areas. I can't remember specifically which ones fall into which bucket, but I believe there were inconsistencies brought up, both from the first trial, the second trial, prior statements to officers in the second trial. But again, I'm not 100% certain which inconsistencies came from which bucket.
But you're saying he did impeach the witnesses just generally?
Yes, Your Honor. I believe he did truthfully a very effective job at impeaching these witnesses and brought up multiple inconsistencies between their testimony and prior statements. And I guess this briefly kind of does go into the impeachment argument that was raised by counsel, and I recognize that this wasn't specifically touched upon in counsel's argument here today. But just in regards to some of the inconsistencies that were raised that counsel failed to impeach, I think one of the instances that counsel did point to where counsel did not impeach Tina as to an inconsistency in her testimony, counsel did in fact do so. And then as to the other two, I think when the court looks at it, and certainly my impression of the reading of the two alleged inconsistencies, I don't believe they rise to the level of inconsistencies. And I think even looking at these, if the court were to consider that this testimony was inconsistent, I think there are a plethora of other options where defense counsel did highlight any inconsistencies between testimony and statements. And I would just point out as well that failure to impeach alone does not prejudice a defendant or constitute ineffective assistance. And I think here, certainly, it does not rise to that level. If there's no further questions, the Commonwealth will rest on its brief.
Thank you very much.
Thank you, Your Honors.
The case is under advisement. The next case is 2023 P475, Commonwealth versus Reed. I believe we're hearing from Attorney Conley first.
Good morning, Honors. May it please the Court, Alex Conley for Mr. Jerome Reed. Your Honor, as the Commonwealth points out, and the Court's well aware of, authentication is a low threshold. However, it's not a non-existent threshold. There needs to be some evidence, something to authenticate a video before it comes into evidence. In this case, all the evidence we really had in this case was video footage authenticated or allegedly authenticated by one officer of the MBCA Police Department. I suggest to the Court that this was the evidence that he presented to authenticate this was well short of even the low threshold for authentication of video surveillance. This was a case, I think everybody would agree, there's no recipient witness testifying as to the way the area looked, anything about what was seen.
So it's fair to say, based on your argument, if the officer had said shown the video and said, I recognize that as the Forest Hill Station. It fairly and accurately represents the way it looked on August 8th. That would have been it.
That probably would have been at least much higher of a level of authentication. I don't want to say necessarily, but I think that's kind of the standard you want to see is, yes, I recognize this. I've been there. I know what this area looks like. He doesn't say that ever.
Yeah, but didn't we have something better? Didn't the defendant acknowledge in the still photo taken from that video that,
So-
yeah, that's me?
The defendant acknowledged the picture that he saw looked to be him, and I attached the photo to my record appendix here to show that it's just a grainy image of an individual. It doesn't show where he is, what the location is really. It just shows the
Right,
single
but we have the
person.
officer who says where he took the picture from.
He says that it was from the Forest Hill Station, I think is the extent of it. I don't think he goes into detail of this was on this area on this date, and that would have been another thing that I think, kind of to Justice D'Angelo's point, would have been enough if he just said, yes, this was a picture from the Forest Hill Station on August 8th, I believe it is, and I was there.
Is there an objection?
There was no objections, Your Honor.
What
So
do we
this-
do with that?
We are stuck with the higher standard here to look to see if this creates a substantial risk of a miscarriage of justice. I think if we were in the prejudicial error place, we'd probably have a much easier case on my end, obviously, that makes it harder, but I think the evidence as a whole was just these videos. And the
Right, but
judge's-
this, I mean, and I looked and I noticed this case was tried to the West Roxbury Division, which is literally a stone's throw from Forest Hills, and I would imagine that judge and really anyone who lives in Jamaica Plain could take a look at one of these videos for a nanosecond and say, that's Forest Hills T-Station.
Certainly, that's a possibility. I mean, we don't have judicial notice being taken by the judge of that, certainly. I think he's relying on the video being the authentic video. I think to make that finding, we'd need to have judicial notice taken. This appears to
Right,
be
but
the-
if the defendant here had made an objection, then the Commonwealth would have had the opportunity to have the witness utter those extra words.
Presumably. I mean, but looking at the record as it is, we can't necessarily, I don't think, make those presumptions that he would have said, yes, I've been
Well,
familiar with that.
but the officer did say the location was Forest Hills T-Station, right? And that he selected these videos as part of his investigation of a report made on a particular day, of an incident made on a particular day, right?
He testified that he began his investigation of an incident at the Forest Hill Station. He doesn't say anything about really further than that, I think, so.
But then he provides us with at least a number of clips that have a date right on them and a time counter right on them.
And that would have been, I think, sufficient if bolstered by some other evidence of the date, why the date is relevant. Because the witness didn't testify here, there's no reason why the date is relevant. Nobody's saying that something happened on that date other than I'm investigating this date.
I guess, and I'm not aware of any case, but I don't think anything precludes it. Couldn't this be authentication by inference? I mean, you have an officer testifying to exactly what he did, looked at a video, and then lo and behold, they introduced the video. Isn't it a fair inference that that's the video he looked at? If there's no objection to it, there's no cross-examination about it?
I think for that to be the case, for us to have an authentication by inference, we'd basically be having to make a new aspect of the new interpretation of the authentication rules and law to do that. I don't think the cases have allowed for this purely inferential authentication. There needs to be actual authentication by the standard that any evidence is introduced by the judge finding by a fair preponderance of the evidence that the video is what it purports to be.
Isn't it
well-
also, I'm sorry.
Assuming the video was properly authenticated, do you agree that when the woman turns around and lays her hands on the defendant, or hand on the defendant, and he turns around and comes speedily up the stairs, is that evidence of flight?
I think so there's a couple different videos involved here. First, there's the
No,
video
I'm
where he-
just talking about the one that shows him looking around, making sure nobody was there watching, and then he does something with the back of her skirt, which is presumably lifts the back of her skirt. And she turns around, and I can't tell if she slugs him, but she puts her hand on him in protest, and then he turns around and starts moving quickly up the stairs. Is that evidence of flight?
I think it could be considered evidence of flight. I don't think it has to be evidence of flight. It could be fear of whatever the person did that turned around and maybe said something to him. We don't know. We just have a soundless video.
Oh, I
but
think
certainly-
she said something to him.
Inferentially, I'd imagine so. But from what we have in the video, I don't think it's required to find that's flight. I know the judge did find it to be flight, and it's one of the other aspects of this case in general is the importance that the judge found of the flight from the videos as to why he knows or he could find beyond a reasonable doubt that a touching occurred. He could not find beyond a reasonable doubt that the touching was indecent because of that.
Yeah, and doesn't that, I mean, that kind of explains maybe why, there was never any issue made over authentication, because in some ways, a video, exonerated the defendant as far as the indecent aspect of it, because the angle of the shot, really, you couldn't see exactly, what he was touching. You can infer, maybe, but in that sense, it didn't actually show the indecent touching, so that might explain why the defendant was okay with the video.
I think from the trial counsel's perspective, that could have been something to consider, is he thinks he has a strong case to get rid of the indecent, the felony aspect of this case, probably the more important aspect of the case. But if the video couldn't have been authenticated at all and couldn't have come into evidence, then there's no case whatsoever because there's no witnesses that are testifying.
Right, but the odds that the video could not have been authenticated had that been a proper objection seem to be none.
Again, inferentially, we can presume the MBTA officer would have been able to authenticate the MBTA video. He didn't in this case, I'd suggest. And then the only other aspect of the case I do want to touch on is that there's also two sets of videos, the MBTA-specific videos and the City of Boston videos.
How do we know which are which? We have a whole string of videos.
Well, Your Honors, I think that the City of Boston ones are the street videos from my, just looking through the
Right, there's the one on South Street that's got the long pole in front of it looking down South Street with Forest Hills in the upper left-hand corner. I take it that's a city video?
That's the way it kind of comes to evidence. Seems like they do the MBTA ones and then the city ones. Some of them and that, as far as the authentication issue goes, those ones, any inferential authentication.
The ones, though, where he's running around Forest Hills, and you see him go back, as you might have guessed, I have some familiarity with Forest Hills, and particularly standing for many, 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 many minutes waiting for a bus to come and that does not follow the schedule. So that's 2 decades of waiting at that bus area, although it has been revamped. So he's running around the station looking like he's going to come in the door from the busway, and then he turns back and runs the other way. Is that a City of Boston video, or is that a T video?
I'd have to look again to just confirm which videos appear to be which ones. I don't have that exact knowledge, relying on what I see in the
I think it would actually be helpful for you to confer with the Commonwealth and tell us.
Tell us which ones are which.
Yeah.
We can certainly probably do that and submit a letter on that. I think that is important just because with the City of Boston videos, especially as it relates to the flight aspect of the case, if those ones even couldn't have been authenticated, it would have called into question the judge's findings on the record of the flight being an important aspect of why he believes beyond a reasonable doubt that a touching occurred. And if some of those videos are the ones that clearly show...
Yeah, but I mean, would that have made any difference? I mean, he took off like a shot, up the stairs right after the incident. So even if there weren't videos of the City of Boston, it really wouldn't make any difference, would it?
I think it could have, just because of the way the judge worded it. Seemed to be fleeing from the station, fleeing from the entire scene versus just running back up the stairs afterward. I think that it seemed to be incorporated in the judge's findings, the flight from the station, which was captured on the City of Boston, which, as noted, I think that those videos in particular, even if the MBTA videos could have been sufficient, those videos, we just don't know how he accessed them. Anybody could have just said, I've seen the City of Boston videos, and I think that's kind of the thrust of this whole case, is that any of us have access to those videos and could see them and then testify later on that we saw these videos and this is what we saw before, and that's all that Officer Tetrault did in this case.
But what's missing, though, is someone saying, well, the time stamp or whatever that's on the video is accurate or is not accurate.
Correct.
Right, because otherwise, you're right, anyone who knows Forest Hills would look at those videos and say, yeah, that's Forest Hills. And what they don't know is how the system works, and they can't confirm that the date is accurate.
They couldn't confirm the date is accurate, the system works. I think Officer Tetrault couldn't even say the name of the system. He said, I don't know the name of the system right now. And one key point that most of the cases talk about the retrieval and the copying of those videos and how they come from where they were to how they get to court that day. That's just not in the transcript at all, and no evidence of that, which is
I'm
I don't
not
think
sure
I've
why
found-
the cases talk about that, because with any image, all you need is somebody to say that's a true and accurate representation of what that area looks like on a particular day. It doesn't matter whether it was recorded, with a very fancy camera or a really crummy camera, as long as you can tell what it is.
True, Your Honor. Well, I think what I'm alluding to is not the cases where that's in play, but with the case where that's not in play, and all you have is the person who's the keeper of the surveillance. That's where that comes into play, and that's how they can do that and get that in otherwise, as that's the circumstantial evidence which allows it.
Well, let me ask you about that regarding the date stamp. Is your argument that there's any question that what was on that video was from August 8th? Because without that, I hate to say it, the defendant could have done this another time. And how do we know that what the judge saw is what he's alleged to have been charged with?
You're right, Your Honor. I think that there's no reason to necessarily question the date stamp, but there's also no reason to verify, just because, as again, Officer Teltrell didn't testify to anything about the date stamps. They were shown. There are date stamps on most of the videos, I believe, and timestamps, but there's no reason to just verify them other than to say the video authenticates itself to the date, which these aren't self-authenticating videos that can just do that. Not seeing any further questions, I would rest on my brief.
Thank you very much.
Good morning. May it please the court. Danny Wolf, 303 for the Commonwealth. I am supervised today by Assistant District Attorney Dave McGowan. We're also joined today by the Assistant District Attorney for the trial, Alex Jones. The Commonwealth requests that this court affirm the lower court's conviction and sentencing of the defendant. There's only one issue before the court today, and that is whether the 14 video clips were properly authenticated. Those 14 clips were properly authenticated through Officer Tetralt's testimony, as well as the circumstantial evidence presented at trial. At the outset, it's worth reminding the court that authentication is a low threshold, as a proponent only needs to show, through a preponderance of evidence, that the presented evidence is what the proponent claims it to be. Here, through 14 video clips, looking chronologically, we see the defendant enter an MBTA bus. The defendant exits that bus at the Forest Hill station. That is actually the exact same bus that the victim exits as well. The defendant then follows the victim into Forest Hill station, into the Orange Line paid fare area of that station, and then on the stairwell, he assaults the victim. He then flees not only from the immediate area of the stairwell, but from Forest Hill station entirely. The videos, again, are authenticated through both the testimony of Officer Tetralt and the circumstantial evidence. Video surveillance is often...
Well, counsel, the authentication was not exactly robust here. I mean, is there a clear statement that these videos, and let's just keep them to the T videos versus the videos, that these videos are a true and accurate representation of the events that occurred at the station, or at least of the areas of the station on a particular day at a particular time?
Your Honor, starting at the beginning on page 18 of the transcript, the officer describes how he first, once the case was assigned to him, spoke to the victim, and he says at the bottom of page 18 of the transcript, relying on the victim's statements, I looked to Forest Hill Station. Then on page 19, he describes how, in particular, he accessed the MBTA's video database, and then searching by date and time, a reasonable inference here can be made that because the investigation began on August 9th, only a day after the assault occurred, and speaking to the victim, he relied on not only the location, Forest Hill, but the date and time, and possibly the location as well, to find that first clip being Exhibit 2A, one of two clips that showed the assault in question. From there, Your Honor, through his testimony, he describes different locations throughout Forest Hill Station and why he, in some of those clips, chose those particular clips, maybe to show the assault or his flight as well.
Do you address anywhere in your brief that there was no authentication of the City of Boston tapes?
No, Your Honor. On page 12 of the Commonwealth's brief, similar language to as I stated earlier, I wrote, I believe, that the City of Boston and MBTA videos were both properly authenticated through Officer Tetralt's testimony as well as the circumstantial evidence.
How does he authenticate the City of Boston tapes?
Well, Your Honor, he describes, again, the location of the surveillance videos, as you described earlier. He says that there's 3 video clips. When they are presented, he says that they are from the City of Boston. So we have we look to Commonwealth v. Cindy Van Tran, where we'd look to the circumstantial evidence here. And in that case, they laid out that substance, contents, internal patterns, and distinctive characteristics can provide authentication.
Well, I mean, pretty much here, anyone else who's ever been to Forest Hills can look at the City of Boston cameras and say that is a true, inaccurate representation or depiction of a particular area at Forest Hills, but they can't give a date.
Yes, Your Honor. This is where it's important to consider that the City of Boston clips are presented 7th, 8th, and 9th by the Commonwealth. So that means that there are 6 previous clips that show the defendant walking through different parts of Forest Hill Station. And it's important to emphasize that all of these 6 clips have date and timestamps for the videos, and the defendant is the exact same attire in all of these clips.
So you're saying that the videos from the T can help authenticate the videos from the city?
Yes, Your Honor. They provide more context. For that, we actually see, as you referred to earlier, it's exhibits 2E and 2F. That is where the defendant is running along the exterior of Forest Hill Station. As you said, he looks like he's going to enter Forest Hills again before running off. Those are both from the MBTA, and as you described, they show the same time, but from different angles.
Those are the MBTA, though?
That's correct, Your
So
Honor.
which ones are the city?
It would be exhibits 2G, 2H, and 2I, Your Honor. As you referred to earlier, 2 of those look to be intersection cams, and 1 looks to be from a utility pole. It's important.
Then I don't need you to further stipulate with counsel. That's very helpful.
Okay, Your Honor. And I would just like to say, Your Honor, that, again, providing context here is important, as the video clips that you referred to earlier, exhibits 2E and 2F, again, the video clips that show the exterior of Forest Hill Station on that upper bus station area. When we first see that City of Boston clip, we actually see the defendant first run along the exterior, he disappears from view, and that's what's actually captured on exhibits 2E and F before coming back into view, running towards the intersection camera, where then the subsequent 2 City of Boston camera are able to capture his flight across the arborway. And then finally, it's worth noting that that is actually bookended by exhibit 2J, which shows, as Officer Tetrault describes, the new head house across the way at the arborway. So,
Right, and it actually says Central Park, or Southwest Corridor Park, right, in the video?
I believe so, Your Honor. It only, believe, Your Honor, it only shows the time and date stamp.
No, there's a wall there.
Oh, yes, Your Honor. Yes, Your Honor.
It says right on it, Southwest Corridor
Yes.
Park.
Yeah, there's a few distinct characteristics throughout. I think in exhibits 2E and 2F, Your Honor, you can plainly see it says Forest Hill Stations on those as well.
Can I talk about the date for a second? And I know this is hyper-technical reading. The officer testifies, or the question is, and did you hear about when approximately that assault and battery happened? I believe it was on August 8th. I believe it was on August 8th. And then later on, there's a question, I believe it's from the trial prosecutor, do you have any reason to doubt the date stamp? No, I have no reason to doubt it. So what we have is a semi-equivocal answer about, I think it was on August 8th, and I have no reason to doubt that that date is correct. Isn't that where authentication becomes important in a case like this, where someone who is the keeper of the records can say, I know it was August 8th for some reason?
Yes, Your Honor. This would be where it's helpful to look to a case, Commonwealth v. Both Commonwealth v. Leviniski, but also Commonwealth v. Gonzalez. In Commonwealth v. Gonzalez in particular, the court emphasizes how the store, I believe it's a hotel manager and an officer that testifies, both view the video together. And the court emphasizes that the management is in position of control over those files, and particularly that they could point to specific time frames. So here, that is an MBTA video, I believe that you're referring to here, and as the officer testified on page 19, he was able to access those videos. So there'd be less a concern that there was possibly an incorrectness because of the control that the MBTA has over those videos.
Are you saying that he's in essence the keeper of the record of those videos? Because that was the hotel manager in Gonzalez, I think. He was the keeper, wasn't he?
He was the person that was able to access the videos, and it would be similar, I would argue, here where, again, page 19 of the transcript, Officer Tetrault describes how, again, as an employee of the MBTA, he was able to log into the MBTA's database, search based on the victim's statements for Forest Hill, and then reasonably infer the date and time as well, given both Officer Pilardi, who is another employee of the MBTA who first took the victim's statements, and then from the victim's statements as well.
We can't use any of the victim statements or anything in that report, right? Was that not brought into evidence?
No, Your Honor, and the officer only testifies that he relied on the victim's statements on the bottom of page 18 to begin his investigation for forced solicitation, but the officer does not testify to any other remarks made by the victim.
The important part, again, about what I believe the victim said is that he believes the incident took place on August 8th. We can rely on that. There was no objection, so even though it was hearsay, it comes in for its full evidentiary value, right?
Yes, Your Honor.
So we can infer that the fact that the police officer has spoken to the victim, is cognizant of the date the victim is speaking about, that officer's seeking to retrieve the videos from that particular date and time, that he's not looking to retrieve a video from a year before.
Yes, Your Honor, and again, the investigation begins the day immediately after August 9th, so just one day after the assault occurred. Seeing no further questions, the Commonwealth would rest on its brief.
Thank you very much. The case
Thank
is
you.
under advisement. Everyone has been wonderful in their arguments this morning. We're going to take a break, and we'll come back for the final two cases.